It's a great pleasure to be here at Best Practices Academy, also known as 24 counties held hostage in a windowless room. I saw one county commissioner at Starbucks going through a can thinking, I think there has to be some coffee left in there, so it's a great thing to be here. I do want to reflect on, there's coffee beans will be available to people to suck on for caffeine during this presentation. I do want to reflect on one thing about Dr. Bell and Amy's wonderful talk, and it's this notion we cannot escape our history, and our history is not that long. I'm going to be 67 years old, and I know it's hard to believe, but so I've lived about a third of our country's life. And I was reflecting on Dr. Bell's comment about how things are baked into the legal system, starting with, it's worth remembering, the United States Constitution, which counted a slave as 3/5 of a white person for census purposes, which meant effectively, when census was used to allocate seats in the House of Representatives, it baked in Southern control of the House of Representatives through the 1960s. A decision made as a compromise to get states to ratify the Constitution. So it's not simply that we bake things from our culture into the justice system. We have baked into our history, into the fundamental document that created the country, a notion of racism, that and an explicit that slaves counted 3/5 of a white person, but that they counted for the overall census of the state, which again meant in the first House of Representatives, had census been used in a different way to only count free people, which was the alternative, the South would have controlled 33 seats in the House of Representatives, but as a result, the South controlled 47 seats. So again, I think it's just worth reflecting, you know, when President Obama got elected, that created a post-racial era in American life, but that didn't really happen. And so I appreciated very much the notion Dr. Bell talked about, which is that we bake certain things, that the justice system exists as part of an overall culture, and the overall culture bakes in history as well as present. So, that being said, we're now going to talk about HIPAA. Usually for these talks, there's they put styrofoam on the table, so when people's heads hit the table, there's a less of a liability issue from the excitement of hearing about HIPAA. But I'm going to ask you to exercise what parts of your brains continue to function in day 2 for 3 questions. Everyone got a little piece of paper? Some of you are too young to remember paper. 3 questions. All right. People are like, I don't know, I can't write. I don't know how to write. All right, question 1. You got to write down, this is just true or false. We're going to go through 3 questions and we're going to come back. You're now, put yourself, you're the local mental health center. An officer, law enforcement responding to a person who might be suicidal calls you and asks if the person that they're seeing on the street is currently a patient in the center. True or false? Under HIPAA, the center can give the officer this information. You got T for true, F for false. All right, question 2. Now you're the hospital. I'm not going to answer these, by the way. I'm just going to ask questions and then turn it over to Chris. Question 2. Now you're the hospital. Jail treatment staff call you to ask for the name of the medication a recently booked person is taking. True or false? HIPAA permits you to provide that information. Question 3. I've got 72 questions, so this is going to be a long... Question 3, now you're a therapist. I used to tell my students I would do exercise like this, and they'd be like, really, please? But the good thing is the exercise assumes you have a job, so be happy as a student that that's your professor cares about you that much. Now you're a therapist meeting with a client. The client appears to lack capacity to make a decision about treatment, and a family member with the client asks you to provide her detail about the client's medication. True or false? Under HIPAA, you can provide the family member that information. Okay, everybody vote? I'm from Florida originally, so we don't count votes precisely, but we do permit you to have the illusion that you voted. All right, question 1. Can you tell the officer responding to a potentially suicidal person? HIPAA permits you to do that. How many say true? And how many say false? All right, the answer is true, right? So, but this, and you're a sophisticated audience, but this comes up a lot because there's a set of misunderstandings about what HIPAA permits. So if you look at Intercept 1, where most of you start. This is the guidance, and there's a reference list at the back, so you can go, so I won't burden you by reading all this, but there was explicit guidance put out a few months ago by the federal government clarifying situations in which protected health information can be given to an officer for certain types of intervention. So that's true. And again, the details, remember, of course, state law may be different, and state law, if it's more protective of privacy, sets the bar. But for HIPAA, that's true. Question 2, can you tell the jail, you're the hospital? How many said it's true you can tell the jail what medication the person's on? And how many say false? I'm sorry, thank you for playing. The answer is true, under HIPAA. Why? Because HIPAA has 5 exceptions in which virtually sort of cover everything a jail or correctional facility does, in which the jail, it's basically an open door into the correctional facility in terms of PHI. Now, I'm going to suggest that doesn't mean you'll do that, but part of what I want you to sort of think about as we talk about this the next 7 or 8 hours is what does the law require versus what discretion does the law provide? And the law permits PHI to be given to correctional facility for these 5 purposes, which cover virtually everything corrections does. So, third one, can you tell the family's member who's sitting there with the client who's about her medication? How many said that's true? And how many say that's false? And the answer to that is true, because this is recent guidance from Health and Human Service on, and it's great, Health and Human Service does pardon me?
It says involved.
Well, it says where a patient is not present or is incapacitated, you can share the patient's information with family, friends, or others involved in care or payment for care. So if the family member attends, and there's several vignettes which illustrate HHS's guidance on this point, all of which is in the direction, unless the patient explicitly says they don't want family involved, that you can provide family with certain types of information. And so you don't have to test the question of is the family member really involved as a caregiver or not. If they show up, it's some evidence that they have some involvement, right? So again, the point is simply that there's guidance on this issue that came out relatively recently. It's quite detailed, and it also is, they provide lots of examples. And here's another one in the guidance. A psychiatrist may discuss the drugs a patient needs to take with the patient's sister who's present with the patient at a mental health care appointment. In fact, my interest in confidentiality predates HIPAA, which shows I lack very much of a life. But when I was the chief lawyer for the mental health department in New York, this question came up repeatedly because families were, in about 70% of the time, the folks to whom hospitals discharge people. And yet families were routinely told nothing about symptoms, about medication, is it an upset stomach because they've got a stomach issue, or is it the medication? And so my interest in this really came from that point, and to try to have some rational way of not overburdening a family member who doesn't necessarily want to know everything, but at least provide some basic kind of guidance. And Health and Human Service, as I said, has come to that point. Now, the point of all this is simply that when you think about confidentiality and data sharing, it's useful to read the law. And I know that may sound silly or condescending, but there's lots of folks talking about legal rules for data sharing who haven't actually done that, and who are temperamentally risk-aversive and confuse their temperamental risk-aversiveness with how their clients should deal with questions. The job of a lawyer is not to eliminate all risk. The job of a good lawyer is to identify risk and stratify it in terms of seriousness, probability, consequence. But some lawyers, and not all lawyers, but you may end up, sometimes lawyers are just fundamentally risk-aversive for a lot of different reasons, and some simply is temperament. And then again, some more HIPAA disclosure, families and payment. So those are 3 just examples that come up currently. So I want to talk very quickly about 2 major points. The first is that data sharing is much more possible than many of you think, though I do understand many of you have data use agreements in place, Chris again being a primary example of that. On the other hand, you'll never get to that point or advance where you are unless you have a framework for thinking about these questions. Too often, the question comes down to, I'd like Megan to give me her, the the PHI. Megan's like, I'm not going to give you a PHI. And that doesn't create a framework. That's just simply an argument about a point of data that may or may not be perceived by both of you in the same way. Part of this issue is the acronyms, right? There's a million laws, not a million, but there's a lot. And there's definitional issues. And again, I won't talk about this in detail, but one of the problems here that we have in reconciling different laws is that each law was passed with a particular set of transactions or a type of data in mind. And so there's not definitional consistency across these various laws. FERPA, the Privacy Act, HMIS all use different phrases with slightly different definitions for the same basic construct. And because they were all enacted to deal with homeless data on the HMIS part, educational data with FERPA, protected health information for privacy. So one of the issues in terms of if you're feeling like this just seems confusing, it's because it is. And because there's never really been an effort to put all these laws sort of in a common kind of definitional and conceptual frame. And it's unlikely that will happen in certainly my lifetime. So what I use to answer these questions is something I found online, the Halloween HIPAA crossword puzzle. And this is available on T-shirts. There's a long version if you like a big T-shirt or a short version. And I just fill in stuff and then I get what the answer is from the HIPAA. Think about how bad it is that HIPAA has resulted in Halloween HIPAA cartoons. I mean, that's really, and think about how sad my life is that I actually took the time to find this. This is really, for those of you who are clinicians, I'm simply trying to provide you with a big mother load of clinical information here. All right, so let's think about a framework, right? And again, this is grossly oversimplified, but you got to find a way to back up from the individual transaction and think more sort of conceptually about what it is you're trying to do. So one way to think about this, and let's use threat to third parties as an example. First question I would always ask, and I made my lawyers ask, is does the law mandate or prohibit a particular disclosure? And that's rarely the case, right? So some states are more definitive in saying you have to take steps to protect a third party. Most states are not. But that's the first question. If it's a mandatory duty, then you kind of have to do it, right? But if it's not, then you get to may I disclose something, which is discretion. And all states say, in the context of threat to third party, yes, you may. A few say yes, you must, but all say yes, you may. And then should I make the disclosure is a third issue. And that's very much a matter of judgment. There's things baked in terms of ethical principles that you operate under as a profession. And so those are three kind of ways to begin to frame thinking about this question. There are very few mandates that are absolute and very few prohibitions that are absolute in these laws, which means that virtually everything else is a judgment. Confidentiality is a core value, but it's not an absolute value. And so that's kind of what the laws try to wrestle with. And then you've got to create a framework, right? So why do you want to share the information? What type of information do you want to share? Who do you want to share it with, and who decides if you get to share it? So what are you trying to share, to what end? And this last question, which Allegheny County is not here anymore because they disappeared, they were in search for coffee and they decided they'd go out. This question of who decides is an important one, which you all may or may not have addressed in your jurisdiction. It's a question of governance and sort of how do you structure access to data and decision-making beyond saying to somebody, well, you decide all this stuff. And so the governance thing, we're not going to talk a lot about. Chris may, actually, but governance becomes part of this as well. So why you want to share information may vary, right? You may want to identify a target population based on administrative data that doesn't disclose information. You might want to identify a geographic area. You might want to do program evaluation. You might want to do data analytics. Or you might want to improve service at the point of intervention, which is a very different thing than all those, right? So the question of why you want to do this is, and again, these sound so simple, but a lot of places don't do this in any systematic way. What types of information? As you all know from your own work, a big fork in the road is it information that identifies a person or not? And if it does identify the person, that takes you down a more complex path. Sometimes you have to have it, sometimes you don't. Health information is governed by HIPAA, housing by HMIS, demographics you can get from census. So I mean, I think part of this, the types of information is also worth thinking about at a granular level, because the conversations often founder on, I want health information for this group of people. Well, do you really need it? How much do you need? Does it have to be identified? Are there other ways to get to the question you're after? Who do you want to share it with? Sharing with law enforcement is different than sharing it with a researcher or a hospital emergency department. And then, as I said, governance. Now, another way to think about this is using the sequential intercept model. Because when you think about the sequential intercept model is a very granular way of looking at how people progress through the justice system, right? And paths out. But at each point, and you've all done intercept mapping in your communities, yes? People are like, please God, just make him in. We'll say yes, and they'll move on. At each, many of you have. This can be the flip side of the HIPAA crossword puzzle t-shirt. It's very tasteful. Each point of intervention, there's something about information, right? So is it useful to track 911 call center calls? Yeah, if you've tried to create some triage within the 911 call center. So that's a point of information. And part of the way I've come to think about this in the context of criminal justice is using the intercept map with counties as a way to, if you're wanting to share data in this sphere, as a way to identify these very granular transactions. And it takes time, it's tedious, but what type of information in that transaction? Who wants it, to what end, how much is necessary, is it archived somewhere, is it available? And it's just, again, because information does or doesn't follow the person, and as information does or doesn't follow the person through this system, you create more or less continuity of care and decision making. And so again, I think it creates an avenue to do that. I talked briefly about intercepts 1 and 2 with the questions. Courts are not covered entities. I had a conversation with one of you, one county before lunch, and courts are a very useful tool. How many of you work in health care more generally? So health systems are increasingly integrated, right? Eventually, we're going to end up with like 10 health companies, and there'll be like a bunch of boutique companies. But part of the reason health systems have grown and integrated themselves is they want to capture as much population health data as possible so they can churn their data, constantly stratify risk, and try to buffer against the administrative costs associated with billing insurance. So big health systems like Intermountain in Utah are trying to, and there's only a handful who've gotten close to this, are trying to get large enough so they can take capitation, so they can eliminate the 17 or 18% of costs associated with administration. But you've got to do that, have amazing data analytics, which are hard folks to find. Some of you were talking about yesterday about that difficulty. And you also have to have the technology to do that. Now, one advantage you have if you're an integrated health system is you sit under one corporate roof. So your challenges aren't legal in terms of integrating and analyzing your data and stratifying risk. Your challenges are, do you have the right decision analytics capacity? Is your medical record up to the task of generating the sort of things that you want to mine for that purpose? What you're all trying to get to, in a way, is you're trying to treat yourselves in your communities as an integrated health system, but without the benefit of being under a corporate roof. So then you have to look to the law to use the tools that the law gives you to effectively act like that. Because your problems, unlike the big health systems, are more likely to be technological and legal. And so the courts become a vehicle to short circuit a lot of things. A conversation I was having with one of the tables here is the probation folks were trying to chase down people on probation to get their consent so they could then get information from the mental health center about whether they'd shown up for treatment. Just have the court write an order every time they put somebody on probation that mandates that. And the court order is consistent with HIPAA, with state law, and 42 CFR, and then that's just a condition of being on probation. And anyway, so I mean, that's a tool in Intercept 3 that can be used to short circuit a lot of work chasing folks down to get a consent. So part of what we're after here is trying to use those tools. How much time do I have? I'm good? I'm good? Chris is like, he's not that good. He's trying to get up. All right. Police officer comes to your facility and asks whether Tex Smith, who's wanted for murder, has ever been a patient. True or false? How many think you can disclose this information to law enforcement? And how many say false? How many say true? How many are like, I don't care about the question, so that's... So, under HIPAA, the answer is true. And here's all the information you can provide. Now, again, you always have to be cognizant, right? HIPAA has been criticized as creating barriers. HIPAA is actually, relatively speaking, wide open with some limits. State law is likely to be more restrictive on some of this stuff because HIPAA was written in an era when technology had advanced to the point people could imagine exchange of electronic information for healthcare. Your mental health statutes were mostly written in a time when all records were paper. And most of your mental health confidentiality laws have not been updated since. So you have a statutory base, many of your states do, that is inconsistent with where the health world has moved, whereas HIPAA is much more consistent with sort of technological advances in information exchange. So you're trying to jerry-rig information sharing, and again, Chris's examples, which he'll talk about, is phenomenally sort of example of success, but you're trying to jerry-rig based on statutes that haven't typically been modernized in years and years. Now, Ohio a few years ago revised its mental health confidentiality laws to conform it to HIPAA in the interest of continuity of care, because in the view of the Ohio folks at that point, the state law, not HIPAA, was creating discontinuity of care. And so there's a lot of that kind of pushing and pulling going on around the country. And then this is the part you'll like, liability. All right, a new employee in your electronics record group just sent a clinical file by unencrypted email, and the email was hacked. The client, after receiving notice, hires a lawyer, not Michael Cohen, to sue you. This lawsuit, some of you are like, what did he say? What did he say? Did I miss something by not paying attention? So, you're going to be sued for violation of HIPAA. This lawsuit places you at grave risk. How many think that's true? And how many think it's false? And how many hope to God it's false? So again, when HIPAA came out, it was sold by two types of folks, right? Software companies sold their packages that would always make you HIPAA compliant. And at that point, a colleague of mine who was way down this rabbit hole long before I was, came back from one of the first software company things on this. And he said, I have a very basic early decision rule, which is if they misspell HIPAA, they're probably not your company to keep you compliant. And then lawyers would terrify people, right? Oh my God, if you do. Plus, you've been, again, Dr. Bell talked about culture and history. It's been baked into you, into the professions for 40 years, the importance of confidentiality. And that bad things will happen if you breach it. But there is no private cause of action under HIPAA. In fact, there's no private cause of action under any of the federal statutes that govern privacy and confidentiality. Now, there's some state law stuff around disclosure and breach, et cetera, but you cannot be sued successfully as a private individual for violating HIPAA or FERPA or HMIS or the Privacy Act or name your poison. So again, we've exaggerated fears of liability to reinforce the importance of confidentiality, and by doing so, I think we've created unwarranted barriers because we don't use what the law legitimately gives us. Finally, the last thing, this is something we're doing in Dallas, and some of you talked about this earlier today, and I think Chris will talk about this as well. Dallas is the 8th biggest county in the United States. We've got a smart justice initiative there. There's 94 hospitals in Dallas County. There's 12 ambulatory mental health centers, and the jail's about 5,200 people. People in Harris County scoff at the Dallas County jail. It's like a small jail like Dallas, please. People in Houston are like, don't talk to us about size. But that's the whole Texas thing, right? Don't talk to us about size. And so through a series of negotiations, there's at least a dozen agreements that knit all this together. there's a hospital foundation that the 94 hospitals give all of their health data to. And there's a mental health authority to whom the dozen mental health providers give all their data. And then the arrest data is all captured in another spot. And so through a series of negotiations, this takes time. 3 of the major 5 systems, so 3 systems representing about 50 hospitals, have agreed to provide their data to a data analytics company. The mental health system is giving its data, and for the first time, hospitals can see what happens to folks in the ambulatory care system. And they're interested in that in the way they never were, because now they're liable for fiscal penalties if people are readmitted within 30 days. And the other way to think about this as a health systems, population health issue, when I talk to criminal justice folks, it's about sequential intercept mapping. When I talk to hospital executives, it's about managing complex populations, one of whom happens to be folks with mental illness and substance use issues who are at risk for readmission, not only for psychosis, but because they quit taking their insulin because they're depressed. And so they show up in the ED for that. They quit dealing with their heart issues because they're depressed or they're anxious or whatever. They show up in the ED for that. So part of this, it's possible to, and this now has just got turned on last week, and it's point of service data feeds to the various people where people show up. The point of it, it's possible, but it has to be knit together, it has to be carefully thought through, and all those sort of things. And sometimes when you're out there negotiating to get beyond where you are with data use agreements, one of the things to think about is who's the audience you're trying to reach. Not just why do you want the data, from whom, whatever, but are you talking to hospital folks, in which case they don't care too much about reducing jail admissions. If you're in jail, you're not in my ED. But they do care about readmissions of complex patients within 30 days that can affect their Medicare reimbursement. And they do get population health, and they do get data analytics, because that's the world they live. So there's ways, I think, to change your lexicon and your kind of ways of thinking, talking about stuff when you're out trying to negotiate, depending on the audience. You do that all the time as it is. But in this area of data use and data integration, I think it becomes really important to think about the language that the various systems you're trying to get data from use, and sort of what's the value to them. And so that, again, is kind of really much all I've got really for the rest of my life. And so this is the last talk I will ever give, and so thank you very much.